So this video is about the European Convention on Human Rights, in short ECHR. After the traumas of the Second World War, the UN's Universal Declaration of Human Rights of 1948 was the first global expression of rights to which all human beings are inherently entitled. The European Convention on Human Rights, an international treaty, was then adopted by the Council of Europe in 1950, ratified by UK in 1951, and came into force in September 1953. So these dates and these years are quite important for your MCQ questions. And the aim was simple of ECHR. The aim was to enumerate a list of inalienable rights possessed by every person and to establish an international mechanism for enforcing those rights. There are 17 key articles relating to rights and freedoms in the conventions outlined in Section 1, Article 2 to 18, which include the right to life, prohibition of torture, the prohibition of slavery and forced labor, the right to liberty and security, the right to fair trial, no punishment without law, the right to respect for private and family life, freedom of thought, conscience and religion, freedom of expression, freedom of assembly and association. The United Kingdom is also a party to the first protocol to the convention, which guarantees the right to the peaceful enjoyment of possessions in Article 1, and right to education in Article 2, and the right to free elections in Article 3. So some of the key points you need to remember for your MCQ. So these are the key articles relating to the rights and freedoms in. And now in the third slide there is a list of absolute and qualified rights. So what are the absolute and qualified rights? Absolute rights are those rights which are not subject to any limitation and which can never be suspended even in times of emergencies. Like some of the absolute rights are in the Article 2, Article 3 and Article 4, the right to life except in the context of lawful acts of war, and Article 3, the prohibition of torture and inhuman or degrading treatment or punishment, and in Article 4, the prohibition of slavery and servitude. And the qualified rights are mentioned in Article 8, right to private life, Article 9, freedom to manifest your religion or belief, Article 10, freedom of expression, and Article 11, freedom of assembly. So qualified rights are those rights that under specific circumstances like public safety, public health and morals, protection of the rights of others, etc., may be restricted provided that such limitations are provided by law, are necessary and are not disproportionate. ECHR provides that where war or public emergency threatening the life of the nation take measures derogating from its obligations under this convention to the extent strictly required by the exigencies of the situation, provided that such measures are not inconsistent with other obligations under the international law. So these measures that can be taken on emergencies are not inconsistent with the other obligations that are given by the international law. So remember what the Article 15 ECHR provides, what it mentions. And then in European Court of Human Rights, ECHR, the international court based in Strasbourg, was set up in 1959 and implements the convention. This is the place where rules or individual or state applications alleging violations of civil and political rights set out in the convention are made. It is also the physical place where rulings are made. So these are some of the important factors about the European Court of Human Rights. It was based in Strasbourg and was set up in 1959. Remember these points for your MCQ questions. And now, ECR and the UK before the Human Rights Act 1998. So before 1998, the ECHR was not incorporated into our domestic law, which meant that it could not be invoked before our domestic courts. So in its first decades, there were relatively few decisions handed down against the UK, although some judgments were significant. For example, Ireland versus UK in 1978, McCann versus UK in 1995, Smith and Grady versus UK in 1999. Other decisions, while not finding a violation, were significant in clarifying the scope of the articles and impacting on policies. For example, Osman versus UK 2000, an impact on policy and practice. In cases where a violation is found, a state party to the convention is under an international legal obligation to ensure that any deficiency in its international law is rectified as to bring them into line with the convention. So these are the relations between the ECHR and the UK, and these are mainly implemented after 1998. Before 1998, it was not incorporated into our domestic law. Then the Human Rights Act of 1998. In 1998, Parliament passed the Human Rights Act. These implemented a Labour Party manifesto pledge to allow rights set out in the Convention to be enforced before the UK courts. While White Paper introducing the Human Rights Bill, our aim is a straightforward one. It is to make more directly accessible the rights which the British people already enjoy under the Convention. In other words, to bring those rights home. And in the next slide, the rights protected under the HRA 1998 Human Rights Act. So Section 1 of HRA 1998 refers to the rights set out in the European Convention rights from Articles 2, 212 and 14 and Articles 1 to 3 of the first protocol to the ECHR. And Article 2, right to life. Article 3, protection against torture or inhuman or degrading treatment or punishment. Article 4, protection against slavery and forced labor. Article 5, right to liberty. Article 6, right to fair trial. Article 7, right not to be penalized retrospectively. And Article 8, right to private and family life. Article 9, right to freedom of religion and conscience. And Article 10, right to freedom of expression. Article 11 covers the right to freedom of association and assembly. Article 12, right to marry and found a family. Article 14, equality and non-discrimination. And Article 1, right to the peaceful enjoyment possessions. And Article 2, right to education. And Article 3, the right to free elections. These are the other rights mentioned in the articles. So remember these articles and the rights related to them, as it may help you in your MCQ questions. The operation of the HRA 1998. So Section 2 of the HRA 1998 requires domestic courts and tribunals to take into account any ECHR judgments and opinions, but they are not bound to follow them. And Section 3 of the HRA 1998 requires courts to interpret legislation as far as possible in a way that it is compatible with the rights enshrined in the Convention. And Section 4 of the HRA provides that where a provision of primary legislation is incompatible with a Convention right, the court may make a declaration of that incompatibility. So there can be incompatibility with the conventional laws and the HRA laws. So for that, there will be declaration of the incompatibility. In the next slide, the Section 6 of HRA requires public authorities not to act incompatibly with the Convention rights and may be liable to pay damages or provide under the other remedies if they do. And Section 7 provides that a person who is allegedly a victim of the unlawful act by a public authority under Section 6 may bring court proceedings against the authority or rely on the Convention rights concerned in any legal proceedings. And in Section 19, a minister of the Crown in charge of a bill in either House of the Parliament must, before the second reading of the bill, make a statement to the effect that in his view the provisions of the bill are compatible or not with the Convention rights. And the supremacy of the parliament. This is an orthodox understanding of supremacy of parliament. Number 1, parliament has the right to make or unmake any law, whatever. In other words, parliament has in United Kingdom no legislative superior. So parliament has the right to make or unmake any law, and it is the supremacy of the parliament. And number 2, parliament cannot bind future parliaments. Future parliaments cannot be bound by parliament of the present. And number 3, no one can question the validity of an act of parliament, including the courts. So whatever the act that is in the parliament, it cannot be questioned by other courts. Now in this slide, the 3 supremacy of the parliament are going to be discussed elaborately. Like number 1, parliament has the right to make or unmake any law or whatever. For example, legislative protection of human rights, Race Relation Acts 1965 to 1976, Sex Discrimination Act 1975, Employment Rights Act 1996, the Human Rights Act 1998, Equality Act 2010. And legislation undermining or possibly undermining of human rights, such as police stop and search power under the Section 44 of Terrorism Act 2000, Gillan and Quinton versus the United Kingdom, and Right to Liberty Terrorism Act 2001 regulating indefinite definition of suspected foreign terrorist, A and others versus SSHD 2004, also known as the Belmarsh case. So this writes that the right to liberty, and this was acted in Terrorism Act 2001, and in the Terrorism Act of 2000 under the Section 44, a case was Gillan and Quinton versus the United Kingdom. So these things you can remember for the MCQ questions, and this may have some other options and you need to choose the right ones. And now in the second supremacy of the parliament, a parliament cannot bind future parliaments. So when the Human Rights Act was adopted, the government stated about repealing or entrenching rights against subsequent legislation that an arrangement of this kind could not be reconciled with our own constitutional traditions, which allow any act of parliament to be amended or repealed by a subsequent act of parliament. So one act of parliament cannot be amended or repealed by another subsequent act of parliament. It cannot bind future parliaments. And in the third one, we do not believe that it is necessary to or would be desirable to attempt to devise such a special arrangements for this bill. Command Paper Rights Brought Home of 1997, paragraph 2.16. And in the next slide, no one can question the validity of an act of parliament. Interpretation under Section 3. The Section 3 of Human Rights Act 1998 requires courts to interpret legislation as far as possible in a way that is compatible with the rights enshrined in the Convention. Section 3 requires more than ordinary statutory interpretation. If considered necessary, the courts will read words into a statute and to ensure compliance with the Convention. But how far? See Lord Nichols versus Lord Millet in Gaiden versus Godin Mendoza, Rent Act 1977, and survivorship rights in respect of statutory tenancies. So let's look into this case. So what happened in this course was that these two, Mr. Ahmad Gaiden and Godin Mendoza, was a homosexual couple. So when one of them died, the other one claimed the possession of all the belongings in the flat in which they lived, but the landlord declined to give him any possessions, saying that you are not husband or wife and how can you take all that. And this was taken into the court, and then court took a look into the Article 8 of the Human Rights Act, and it stated that not only for heterosexual couples but also homosexual couples have the right to possess the belongings of their partner, and that's what its case is all about. And Section 3 requires the court to make a distinction between legitimate interpretation and effectively undertaking the drafting of legislation. W&B Children Care Plan 2002, the House of Lords concluded that Court of Appeal's interpretation of the Children Act 1989 could not be upheld. Section 4 of the ECHR provides that where a provision of primary legislation is incompatible with the convention right, the court may make a declaration of that incompatibility. A court may still quash or invalidate subordinate legislation, such as regulations or orders. If a conventional right and a human rights does not match, then the court may make a declaration of the incompatibility. They have the right for that. And A and others, SSHD 2004, Belmarsh case. So the House of Lords decided that Section 23 of the Anti-Terrorism and Security Act of 2001 was unlawful under the Human Rights Act 1998, and in violation of Article 5 and Article 14, the House of Lords declared the Anti-Terrorism Act incompatible with the ECHR under the Human Rights Act. So that's how they declared the incompatibility of their act with the acts of the Human Rights Act. Declaration of incompatibility of reability of the Home Secretary to decide the minimum period of incarceration for a murderer. So incarceration means the period a murderer or a convicted person he stays in a jail before his punishment. So this murderer was given a death sentence, but before that he was given a long time in jail, and this was not a fair trial, and this was found a breach of Article 6 in the Convention, which is right to a fair trial. Every person and every criminal has the right to a fair trial to reach a ending point. The law was changed by the introduction of the Criminal Justice Act 2003. So remember these dates, remember these article numbers, remember the Criminal Justice Act, these names, and these will be very helpful in your MCQ question. The declaration does not invalidate the incompatible legislation. Once a declaration of incompatibility is pronounced or a violation found, it is up to the government and parliament to take steps to amend or repeal the legislation. Now, it is the government and parliament's responsibility to take steps to amend it or to repeal it, because the declaration does not invalidate the incompatible legislation. Some countries or some places might have different laws, but they can be amended and they can be repealed. And in Section 10 of the Human Rights Act 1998 provides for a fast-track procedure to amend legislation. A fast-track procedure to amend the legislation was in the Section 10 of the Human Rights Act 1998. So these are the ECHR and HRA slides of the public law.